If it pleases the court, good afternoon, Your Honor. My name is Susan Jarvis, appearing on behalf of the claimant. And as stated in paragraph 1 of my skeleton argument, this is an application pursuant to CPR Rule 25.1, Sub-Rule 1A for an interim injunction prohibiting the defendant from holding a clay pigeon shooting competition on his property located at the Oaks Farm, number 2 Far Lane, Netherbury, Cambridgeshire. For your reference, Your Honor, the relevant rule is located at page 797 of the White Book, Volume 1. You will also note from paragraph 2 of my skeleton argument that the application is made without notice to the defendant as permitted under CPR Rule 25.3, located on page 827 of the White Book, Volume 1. The reason, Your Honor, for making the application without notice is due to the urgency of the claimant requiring an injunction to prevent the defendant from holding a clay pigeon shooting competition scheduled for 19th July 2020, which can prove to be detrimental to the claimant's business. Your Honor, I direct your attention to paragraph 3 of my skeleton argument to reassure the court that despite the application being made without notice, those instructing me have indicated that in accordance with the requirements of Practice Direction 25A, paragraph 4.3, subparagraph 3, which is found on page 865 of the White Book, Volume 1, the defendant was given informal notice earlier this morning via telephone, and he has indicated that he will neither be attending the hearing nor will he be legally represented. Your Honor, I have been informed that you have read the bundle of documents and exhibits which I have outlined on the paragraph 4 of my skeleton argument. Therefore, instead of reciting the facts of the case, I will instead draw your attention to paragraph 5.2 and 5.3 of my skeleton argument. Your Honor, those two paragraphs highlight to the court that the clay pigeon shooting competition, which the defendant intends to hold in an area on his property, will very likely have detrimental consequences for the claimant's business arrangements. Because, Your Honor, you will note from Exhibit JD1 that the clay pigeon traps which have been erected are dangerously close to the stable where the claimant houses 3 mares which are currently in foal. This, Your Honor, segues into paragraph 8 of my skeleton argument, which puts the spotlight on the crux of the matter. Your Honor, the issue between the parties for the court's consideration is whether an injunction should be granted to protect the claimant from being affected by the clay pigeon shooting competition which the defendant is planning to hold on his property. Your Honor, the court has the power to grant an interim injunction pursuant to CPR Rule 25.1, Sub-Rule 1A, and also pursuant to Section 37(1) of the Senior Courts Act 1981. I take you to paragraph 6 of my skeleton argument, where the relevant section of the Senior Court Act states, and I quote, "The High Court may by order, whether interlocutory or final, grant an injunction or appoint a receiver in all cases in which it appears to the court to be just and convenient to do so." Further, Your Honor, where the granting of a prohibitory injunction is concerned, in the landmark case of American Cyanamid versus Ethicon Limited 1975, the court laid down some principles which are outlined at paragraph 7 of my skeleton argument, which a court should consider when determining whether an interim injunction should be granted. An applicant must show that, 1, there is a serious question to be tried, 2, that damages would be an inadequate remedy for the claimant, 3, that the claimant's undertaking in damages is good protection in case the injunction is wrongly granted. 4, the claimant will suffer a greater prejudice if the injunction is granted than the defendant would suffer if it is not granted. The court has also indicated, Your Honor, that where the foregoing principles have or are evenly balanced, the court should consider preserving the status quo and should also consider any special factors. Your Honor, I will now make my submissions in respect of the first 4 principles as those specifically pertain to the claimant's application. First, it is submitted that there is a serious question to be tried. The claimant will be interfered from the use and enjoyment of his land if an injunction is not granted. You will see from paragraph 10 of my skeleton argument that the defendant's activities will amount to nuisance to the claimant, who will be affected by the planned shooting competition because of the potential drawback that it could have on the claimant's business. It is noted, Your Honor, in paragraph 10.1 of my skeleton argument that the claimant's business is concerned with the breeding, rearing, and training of race horses as outlined in paragraph 2 of the claimant's witness statement. Clearly, the shooting noises that will be heard continuously for the duration of the competition could potentially cause the mares to go into labor before the appointed time, and this could prove fatal to the foals, as the claimant would have stated in paragraph 12 of his witness statement. Turning to the issue of the adequacy of the damages as a remedy for the claimant, it is submitted that damages will be an inadequate remedy for the claimant. Your Honor, paragraph 11 of my skeleton argument states that the loss which the claimant could suffer may not be translatable into money terms. I make specific reference to the 20 years of goodwill that the claimant has fostered with his clients, which could potentially be destroyed if the defendant is not restrained from holding the pigeon shooting competition. I also respectfully submit, Your Honor, that presently there is no evidence to show that the defendant is in a financial position to afford to pay damages that he may be ordered to pay if he causes financial loss to the claimant. Because, Your Honor, as I would have previously mentioned, the defendant is not present in court today, and there is no one here to make any such representation on his behalf. Furthermore, Your Honor, it is submitted that in accordance with paragraphs 12 and 12.1 of my skeleton argument, the claimant's undertaking in damages is good protection for the defendant should it turn out that the court should not have granted an injunction to the claimant. It has been clearly established that the claimant is a successful business owner for the past 20 years. So there is no doubt that he will be able to make good on his undertaking in damages. Therefore, it is on this basis, Your Honor, that we concur with Lord Diplock when he stated that there would be no reason to refuse an injunction on this ground. Your Honor, as it pertains to the 4th principle, it is submitted that if the court is still not convinced that an injunction should be granted in favor of the claimant, it is posited that the claimant will suffer a greater prejudice if the injunction is not granted than the defendant would suffer if it is granted. It is important, Your Honor, that the balance of convenience be taken into consideration, because we have already determined that damages will not be an adequate remedy for the claimant. Your Honor, I will quote the words of Lord Hoffman in National Commercial Bank Jamaica Limited versus Olint Corporation Limited regarding the balance of convenience, as set out in paragraph 13.1 of my skeleton argument. He was quoted as saying, This is often an exercise in seeking to determine whether granting or refusing the injunction will cause irremediable prejudice and to what extent. End of quotes. Your Honor, I submit that the claimant stands to be severely prejudiced because the financial viability of his business will be affected if the court refuses to grant an injunction. I refer you to paragraphs 13.2 of my skeleton argument, which references paragraphs 8 and 9 of the claimant's witness statement and Exhibit JD2. You will see, Your Honor, that the claimant has entered into a contractual arrangement with a Texan billionaire who has purchased the three foals for various prices as quoted in Exhibit JD2. The claimant has also stated that it is expected that after the foals have been sold, there will be a further contract to bring on or train each foal. Further, Your Honor, the claimant is quoted as saying that these contracts are very important to the stables and to the financial health of his business. Your Honor, a simple recreational activity which is purely fun and games for the defendant and his guests could result in huge and, dare I say, irremediable financial loss to the claimants, who, by the way, has been operating his business for the past 20 years to the defendant's knowledge. In closing, Your Honor, I reiterate that on the basis of the principles laid down in American Cyanamid, which favor the claimant, it is submitted that the claimant should be granted an interim injunction because of the following. 1. There is a serious cause of action of nuisance which is to be tried. 2. Damages will not be an adequate remedy for the claimant. 3. The claimant can make an undertaking in damages to the defendant, which is good protection for any loss that he might incur. And 4. The claimant will suffer a greater prejudice if the injunction is not granted than the defendant would suffer if the injunction is granted. On the basis of my foregoing submissions, Your Honor, I repeat that it is absolutely necessary for the claimant to be granted an interim injunction. If it pleases the court, thank you.